I'm an attorney with the Autism Advocacy and Law Center. We are not your standard, law firm. You're not going to see my face on a billboard, on a bus stop sign, advertising a sporting event. We are not that kind of attorneys. We're not that kind of firm. Our sole purpose is to serve the disability community in Minnesota, with really an emphasis on folks in the autism community, including parents, caregivers, and individuals themselves. On the autism spectrum, I have been with my law firm, which is the Autism Law Center, for over 10 years, and I've been managing attorney for just over 8.5. We are 4 attorneys strong and 2 very, very, very talented legal support staff who essentially are the glue that will be together throughout the day. This afternoon, the topic of the presentation is going to be special education advocacy, your students' rights. So as an attorney, I say I'm a litigator. What that means is that doesn't mean that I'm in court all day, every day. It means, though, that I'm always preparing to go to court if I have to go to court. And in the context of special education, that is what's called going to due process. So anytime you and your school district have a dispute that you cannot resolve between yourselves, so between the parties, either party, so either the district or the parents of the student, have the option of what we call going to process, which is kind of the phrase you might hear if you've been through this or you're thinking about suing your school district. Over the course of my career, 10 years at the Autism Law Center, I've represented many, many parents and students in due process cases, and I think we've probably at this point taken over 8 to trial. That due process trial looks and feels like almost any other trial like you would think of. I'm not going to say on TV, but like you see the courthouse. You've got a judge, you've got opposing counsel, you've got the attorneys for the students, you've got witnesses, but it doesn't take place in a courthouse. It takes place actually in your schools. So if I live in Rochester, and my kiddo has an IEP, and I sue Rochester Public Schools, my trial actually will not be at the Olmsted County Courthouse. It's going to be somewhere within the Rochester Public School District. We get a judge who is not a district court judge, not selected. And that person is an administrative law judge. They're an employee at the Office of Administrative Hearings. That person is our decision maker. So that is the person, that is our audience when we go to process. When we are talking about where does the law come from in special education, it's primarily the Individuals with Disabilities Education Act, also referred to by its acronym of IDEA. The IDEA requires that school districts who are servicing special ed students provide IEPs. So that's the binding document that either parents and districts agree to or order, so the LHA would order, be implemented to provide special education and related services to a student. IDEA was passed by Congress decades ago to really help stave off a lot of individual civil rights lawsuits that would be brought against school systems on behalf of people with disabilities. So we had the successes of the civil rights movement. We had integrated schools by race. The disability rights movement really kind of took a page out of that playbook and started bringing very similar claims against public schools. Public schools have always been really kind of ground zero for civil rights litigation for protected classes of people. So after Brown versus Board of Education was successful in integrating schools by race and ethnicity, disability rights advocates realized, hey, we can use that same type of strategy, and they started winning cases. In response, Congress passed legislation IDEA to provide states resources and framework servicing kids with special needs to avoid further lawsuits against the states and against local public schools. Every district that receives federal dollars, which is pretty much every public school district in the country, at least I can speak to Minnesota, every public school district in Minnesota receives federal dollars. to help fund their special education services. They have what's called a child find duty. Rochester Public Schools, am I saying it right? Is that what? Rochester Public Schools has a duty, an affirmative duty, to go out there within its four corners, within its boundaries, and find students who require and are eligible for special education and related services, and actually find them. So the way they can go about doing this, there's lots of ways. So they can work with daycares, they can work with hospitals, they can work with pediatricians. They can go door to door. They can go to they can observe kids in preschool types of settings. It doesn't, the idea doesn't say exactly how districts have to discharge their child find duty. It says they have to. So that affirmative duty is on school districts to go and find kids who qualify for STEM services, special ed services, and provide them. That is one of the claims that you'll see brought if you read the case law in this area. A failure to complete a child find. So a failure to identify a student who qualifies for STEM services and then failure to provide those services. That would be a common complaint or account you see in a due process. Yeah. As I said here on this slide, the child find mandate requires each state to come up with its own method to determine which kids need special ed services, evaluate them, and provide them. And guess what? At no cost to parents. So by the letter of the law, you as parents don't have a duty to go out and get your own neuropsychological evaluation. You can, you certainly can, and you should. That's my advice today. Some of the litigation history. You should get your own neuropsych evaluation for a lot of different, but you don't have to in order for your kiddo to qualify for STEM services. The school district has an obligation to find, evaluate, and start providing the services all at no cost to parents. And again, that's one of the areas where they mess up, and that's one of the areas where districts to this day still continue to face losses for failing to even identify and evaluate those kids. There are, I don't want to get too much into sort of the statute because I want to be able to respond more to folks' real life concerns and questions about what's going on sort of right now with special ed services. But there are essentially two parts. So there's the early intervention part, 0 to age 3, and then age 3 and above. Age 3 and above is where we start to get into IEP territory, and that's where it could qualify for an IEP or an individualized education program. So slightly before age 3, when a kiddo would qualify for those IEP services, we recommend having a transition with your school district to determine eligibility to start receiving special education IEP services. There are certainly going to be some situations where a school district provides those early intervention services, and then the child, the student, receives the services they need, and then by age 3, don't qualify for any more services. I think that could be in some situations a really good outcome if the district does its job right. Keep in mind, my job is to go through records and find where districts have done not the right thing and where there's liability. But if districts do their job right, of course, there are going to be situations where between 0 and 3, they provide sufficient services so that a student may not be eligible by the time they are 3 years old for ongoing special education. But we do want to make sure that we do have that meeting with your district prior to age 3 to determine ongoing special ed services. The evaluation is an important part of this process because that's kind of the procedure. That is the procedure a school district has to go through to determine whether a student qualifies for STEM services, under what category, what their special education needs are, and then after that, the district has an obligation to use that special ed evaluation to propose a plan. So the way this works is the district evaluates. They generally hold an evaluation results sharing meeting. Everyone's invited. Parents, a parent can bring an advocate, a parent can bring an attorney. The district will have their staff there. They should have the people who are doing the evaluation present. Sometimes districts, if they're smaller, and I might get the sense that Rochester Schools is probably not a small public school system, but if it's like, say, you know, Monaga, Minnesota, near where I grew up, population 500, they may contract with the co-op or some private practitioners to do part of the evaluation. That's fine. The idea doesn't say that the district has to have only district staff do the evaluation. Point is, if there are outside folks who are doing, say, the speech evaluation or are doing an OT evaluation, they really should be there at your evaluation sharing meeting to go over the results and talk through what the IEP should look like. I am slightly cynical because I've been doing this for a while and I've sued lots of public schools. I think by the time we get to an evaluation results sharing meeting, most school districts have already made up their mind as to whether the child qualifies and whether whether their intention is to offer an IEP or not. So, you know, keep in mind, one of the results of an evaluation could be a district could determine that a child doesn't qualify. So then what are your options? Or the district could determine that, yes, this child qualifies for special education and related services. If they determine that the kiddo doesn't qualify, you do have some options. I suppose, like we tell potential clients and clients all the time, first option is to do nothing, which is not usually a great option, but that is an option. You could request that the district do a 504 plan. Section 504 of the Federal Rehabilitation Act is another piece of legislation from which derives some special education protections for students, though not as robust as with the Individuals with Disabilities Education Act. So you could request a 504 plan. I kind of think of a 504 plan as sort of like an IEP light, like a junior IEP. It can memorialize some agreements you have with the district. It can memorialize disability. It can memorialize, you know, what steps the district promises to put into place to support the student with a disability. But if they don't follow through in their 504 plan, your recourse, your remedies are really limited. In IEP land under IDEA, I have all my due process rights. So if I disagree with how an IEP is implemented, I get to go to due process and I get a decision fairly quickly. With a 504 plan, it's not the same thing. If I have a disagreement with how a 504 plan is being implemented, I can request a hearing. The superintendent or the principal gets to pick my hearing officer, so question how impartial that person is going to be if they're being paid for and selected by the school, and then whatever the result is, essentially we have to live with it unless you're willing to then appeal to federal district court. That's not my preference. I like the structure of IDEA. I like the structure of due process. So whenever I can, if we can spring from the evaluation into an IEP, that's my preference, because as a practitioner, it provides more protections, both substantive and procedural protections for my clients and for their kids. I think it's important to point out that an evaluation needs to be very comprehensive. So it needs to be full, the first point here. And so it needs to, you know, they can't just do IQ testing and be done with it. And not that I've seen that a district tried just that. But they have to evaluate sort of in all areas of need that a student may have that affects their education. So some of the areas where I tend to see districts not test, that parents tell me they should be testing more for, are sort of the adaptive behaviors and the functional behaviors. So you might have a student with an IQ of 120 who aces all their tests, but has a hard time regulating their behaviors, is not able to remain in the classroom for longer than 15 or 20 minutes without having a behavioral incident. So that student obviously may not have any academic needs, but certainly has some behavioral needs that can and should be met through IEP services. And that needs to be evaluated as well. It's not just enough for teachers to do informal assessments. It's not enough to have school psychologist or nurse stop by. What we need is a full, robust evaluation to determine eligibility.
So would that be a VIP versus an IEP, or would it still be in an IEP?
So the question is whether that type of intervention would be a behavior intervention plan. Is that what you're asking? That's the VIP. So the behavior intervention plan is part of the IEP. It just gets tacked on the end, but a behavior intervention plan is part of the special education and related services that a district is obligated to provide. So sort of one and the same, two components of the same document. Yeah. As I said, once an evaluation is complete, we hold these evaluation result sharing meetings. Definitely attend. There is some negative case law out there, not necessarily in the 8th district. We are in Minnesota, we're in the 8th district, 8th circuit, Court of Appeals. I'm not aware of any recent negative case law in the 8th circuit, but there is from the 9th circuit, which is like California, Hawaii, out that way. If parents don't participate, so if the district does these evaluations, proposes IEPs, holds these meetings, and parents just like don't show up for whatever reason, they're mad, they're angry, they don't trust the school. There's a personality dispute between them. Essentially, the 9th circuit says now you waive your rights. So you have to show up to these things, whether they be by Zoom, in person, calling in, whatever. For some parents, it can be hard to get time off of work. So districts then we request that they hold meetings early in the morning for work, after school, so that parents need to get there after school. One of the issues is teachers are, for the most part, union employees, so they're on contract at certain hours. So it's really hard to get them to stay past 5 unless they're really agreeable to doing so. But before, I've been to many 7 a.m. IPT meetings, and those would be a way to accommodate parent schedules. But do show up so that you don't waive any of those rights. If you disagree, here's another option. If you disagree with the district's evaluation, you can ask for an independent educational evaluation. And the idea there is to give parents the opportunity to go out. I would say they're in the state of Minnesota, at least, in the metro and greater area, there are probably 5 to 7 people or organizations who I think do a really good job at doing IEPs. And so the point here is to give the parent an opportunity to go and engage a neutral, independent third party to essentially get a second opinion, have them do the evaluation over from scratch or parts of it that are contested. So a lot of times an IEE is not going to be an exact duplicate of the school's evaluation. IQ testing, I keep on getting back to this, really doesn't change over time. So sometimes we don't even do updated IQ testing every three years because it just doesn't change. Behavioral testing scores, adaptive behaviors, functional behaviors, academic performance, that can all vary greatly over time. Executive functioning, depending on the level of interventions we're giving, that can also vary greatly over time. So an IEE is not going to essentially duplicate every single thing that the school did, but get to the contested or the disputed issues, and then give the team another perspective on how that student is doing and whether IEP services are necessary to address any needs that the schools missed. The IEE does have to be at district expense. They hate doing it. Districts are notoriously frugal, except when it comes to attorney's fees, which is something I've never worked for school districts. I've never worked for a law firm that represents school districts. I have a lot of colleagues who represent school districts. They are well paid. There are 3 law firms in the Twin Cities who represent school districts throughout the state. They are well paid, and in those districts, those attorneys are being paid by people like Rochester Public Schools. So every time they say your district says, no, we don't want to pay a para $15 an hour, keep in mind they are paying attorneys $300 some an hour to work on cases and avoid litigation or engage in litigation. So The IE does have to be at the district expense. If they don't want to pay for it, they can do what I call reverse due process. So when I think of due process, I usually think of parent versus the school district, or student versus the school district, or parent on behalf of student versus the school district. The district can reverse due process, meaning if they say, if the district says, we did everything right, we did all of we evaluated every area, we did it twice, we did it 3 times, we don't think there's any possible way that an IEE provider would come up with any different result, we'll see in court. They can then go to a hearing officer and say, they can file their own due process complaint and say what the parents are asking for is unreasonable. Look, judge, here's our evaluation. It's complete, it's comprehensive. There's nothing wrong with it. And then we let the court decide. Most ALJs, administrative law judges, I think are going to err on the side of caution and say, why don't you just do the IE? I think situations where they might be hesitant is when there are 3 IEs in the past 5 years, because there are some parents who are very aggressive, and rightly so, in their advocacy, and sort of know what their rights are and get these things. So I think in general, you're probably going to get your IEE unless you're asking for them every year. And it can be a worthwhile thing to do. I just had one down. I had a case right now with Wasika schools. And we asked for an IE and just said, sure, you pick. We're not even going to give you a list of people. You just go pick who you want. As long as they check out, we're going to pay for it. And we had our IE results meeting last week, and it was really good, actually. The student, we found out in the last 4 years, has made almost no progress with reading, but has made really good progress with math. So the trick there is not the trick, but the issue now for the district is, why is this student for the past 4 years, why is the student for 4 years basically made no progress with reading, and then how to do that? So the IEP can be a very valuable tool for parents. The IEP team, I'm not going to get too much into this just because a lot of you know, a lot of you are members of IEP teams. Parents, a regular ed, general ed teacher, a licensed special ed teacher's got to be there. When appropriate, the child can attend. So if I'm working on a case and the child is 16, I might have the child attend. We might be working on self-advocacy as a skill in the IEP. Great opportunity for the child, the student, to practice their self-advocacy skills, come to an IEP. If the child is 6 or 7, I probably would not have that child attend. I think that would probably be inappropriate and not a good use of that person's time. A district representative and a teacher licensed in that particular student's disability. We can always waive having people attend if we want to. I understand that scheduling can be difficult. I understand that my schedule can be difficult. I understand that opposing counsel's schedule can be difficult. So sometimes we do end up waiving some of these people attending. So say, for example, I have a situation where a kiddo within a section is in a level 4 setting and is never in the general education setting. If the gen ed teacher isn't available, I'm not going to probably, pound on the table and stop my meeting and say, we have to wait till next week. Sometimes we just need to have that meeting and go. So sometimes we do waive certain people attending if I don't think it's going to make a difference in the outcome of the meeting. One word of caution, or one word of awareness, rather, is if you lawyer up, the district is going to lawyer up. So and the reason is, I, as the attorney, cannot speak to an opposing party who's represented by counsel. Anytime I get involved, or another attorney gets involved representing parents and students, the district will lawyer up, and then I'm not allowed really to talk to them in any substantive matter other than saying, we'd like an IEP team meeting to discuss my client's concerns. Anything other than that has to go through the attorneys. So if you show up with an attorney, they're just going to cancel the meeting and say, well, we schedule for a time when our attorney is available as well. So again, there's about 3 law firms in the Twin Cities whose core constituencies are public school systems, districts, and pretty much know all the attorneys who do the school district side work, and that they're going to be there if we have an IEP today. There have been maybe 1 or 2 cases in 10 years where the district's attorney said, I'm not going to be there because I think we already have a plan worked out ahead of time. If it goes south, go ahead and cancel the meeting, and then we'll reconvene. And in both of those cases, it went just fine. But we had sort of worked everything out ahead of time, and it was kind of smooth sailing by the time we got to the meeting. A lot of these meetings, as everyone here knows, as everyone tuned in knows, logged in knows, are not necessarily going to be smooth sailing because we're asking for things and the other party doesn't want to give them to us. The IEP team has to consider but not adopt recommendations of outside providers, which can be a very frustrating thing for people. For example, you might have an outside diagnosis of dyslexia, and your school IEP team might say, we don't recognize dyslexia as a disability or a category of special education need. We recognize specific learning disabilities. We recognize language processing disorders, but we don't recognize dyslexia per se. So they don't have to necessarily adopt all of the interventions that you get from your neuropsychological evaluation. They don't have to adopt recommendations at all from your IEP if they don't want to. Now, if they don't, think about what kind of liability they're creating for themselves. It probably would be unwise to decline to adopt some IEP recommendations. But there's kind of this constant struggle between the educational model of providing services and the medical model of providing services. And they are different. Schools can't diagnose, they can only determine eligibility under federal and state law for special ed services. They cannot say your kiddo has a medical diagnosis of ASD, ADHD, Down syndrome, whatever it is. I think this is really important, the present levels. So there's been some really good litigation about this, that the IEP needs to capture your kiddo's present levels of academic achievement and functional performance. Here's why. If we don't know how that child is performing on October 1st, 2023, when we're doing our IEP that will last until October 1st of 2024, if we don't know exactly how that student is performing, we can't create goals and objectives that are that can be met or intended to be met within a year. I had a case back in 2016 against Stillwater Public Schools. We won, and that was one of the main reasons that we won. The school kept on proposing the same IEP over and over and over again over the course of years. By the time we got to trial, and I cross-examined special ed case manager, I cross-examined every single person who had anything to do with the evaluation. The present levels, we went to trial in January, and the present levels that were proposed were left over from the previous spring. So the present levels were captured in May of 2015. And by the time we got to trial, it was January of 16. And each of them said, no, the present levels here are not correct. And I would put this for how many sight words the student can read instead of what's in the IEP. Or I would say the student the student is making eye contact, 80% of the time, not 20% of the time, that the present levels say the student is. So that was one of the main reasons that we won, is because the IEP proposed didn't even capture how the child was doing at the time. Judge Lefebvre took real issue with that and said, school district, I'm finding you liable. You are not proposing an IEP that is designed to provide FAPE, free and appropriate public education, because you can't even do your most basic fundamental job of getting a snapshot in time of how the student is doing now. So we won, and then we got our fees paid for, which was a good result. In addition to the academic performance, again, for most of the clients that we serve and their kids, we really want to make sure we don't miss the functional performance, the adaptive behaviors. Again, we've got plenty of kids who have great IQs, well, academically, but do have some deficits in special education needs related to behaviors, which is, and then in school with their peers is where we want to be addressing them. So that should be in the IEP. The goals in an IEP, I think most of us know, they need to be measurable, and they need to be met within a year. So that, that's straight out of the statute. If, one word of caution or warning or awareness is, if your student doesn't meet that goal within a year, that is not a per se reason to go to due process and win. So there's plenty of case law that says in which parents have sued their public schools to due process, and on the basis that you proposed an IEP in October of 2023, and by October of 2024, my student did not meet any of their goals. That is not, you can't hang your hat on that and say, and go into court and say, the reason that the school didn't provide FAPE, my only evidence is that the student didn't meet their goals. You gotta have something else. You gotta have something other than that. I can probably, or other attorneys in this area can probably find reasons, failure to provide appropriate support. Gosh, coming out of lockdowns and COVID and school closings, failure to provide staff, the inability to provide the same services, through distance learning. We can come up with lots of really good reasons why I think that student did not meet their goals, but not meeting the goals is not a per se reason to create liability for the district. The least restrictive environment, that's right out of IDEA. So kids, students who receive special ed services have to be educated in the least restrictive environment possible, which means with their general education peers as much as possible. So the trend that we're seeing, or that we should be seeing, is kiddos mainstreamed in the gen ed setting as much as they can, and then pulled out only as necessary to get their special education minutes. And that needs to be in your document, because the MDE does, the Minnesota Department of Education does keep track. They want to know how many federal level 4 setting kids are in each district, how many level 3, level 2, level 1. And they're doing it for good reason. I'm not always the biggest fan of MDE, but they do some really good work. And they do some good data tracking. And so if you want to know in school district 22, I don't even know what school district 22 is, how many kids attend, how many get IEPs, and how many are in a level 4 setting, MDE will be able to tell you that. So if we are doing some litigation and we're trying to get from, say, so violation of least restrictive environment is oftentimes one of the claims that we bring. So a district may want to keep a kiddo in a level 4 setting away from their gen ed peers because of behaviors, whatever reason the district is giving. And if we're wanting to bring that claim, we can do some investigation and say, this is in District 22, where we've got, 30% of the kids on IEPs are in the level 4 setting, and we go next door to District 21, and only 8 are in the level 4 setting. So we can bring in that kind of evidence and argue to the court, look, this district is unfairly segregating kids with autism, with whatever disability might be in question, because look, we have more than double the amount of kids in this district in the level 4 setting. So that can be some really useful information to bring into a hearing. The 4 most common ones that you're going to see in an IEP are 1, 2, 3, and 4. I'm not going to read them for you, but essentially it's the setting is determined by how much time the student is in the special education classroom versus in the general education setting. Level 4 would be a separate, would be someone who's going to school, usually full-time, and they receive all of their services in a separate school more than 50% of the school. Related services, I think, is really interesting because it's not just the core academics. So schools, dean schools are oftentimes really good at making sure kids get appropriate academic support. Because that's during the traditional school day. And that's kind of the model that most people who have been educators for decades are used to. But related services can extend to non-academic activities. So it extends to recess, it extends to any type of school programming after school. So under Minnesota case law, the yearbook, sports, what are we in football season? I'm not a football player. Wait, so I have a kid who's on an IEP who wants to play football, and we need accommodations, and the district is having to provide them. And they're happy to do it. They realize, their obligation. So prom is another one here on the slide. There was some case law regarding prom. A special ed student wanted to go to prom. I forget whether it was a federal or state case, but we got a decision that prom was indeed a related service because it was a program offered by the school to all gen ed students. So as a special ed student, that special ed student was allowed to attend, and the school had to provide appropriate accommodations, typically staffing, to allow that student to attend prom. Program modifications, every child is going to be different in what their educational needs are going to be. We see a lot of, at least in my practice, modifications for testing, so reading tests allowed to students, giving students extended time, breaking larger projects into smaller chunks, chunking, scaffolding. We're all kind of used to that language. So those are all, some good examples of really the some common ones: preferred seating near the front of the classroom, the ability for the student to wear noise canceling headphones during the school day, the ability for the student to have fidgets, anything to help with some stimming behaviors. All of those things are kind of modifications that I've seen. And for the most part, as long as what you're asking for isn't, really disruptive to the educational setting, most districts are pretty okay with it. Tech is a big one. So an IEP I'm working on right now, where we had an IEE. The IEE evaluator said, you just need to stop trying to force this kid to learn to have good handwriting. He's 14. We are looking at him going into the workplace, and you just don't, in the workplace, need to write out paragraphs by hand. That is not something that most of us do anymore. So we've got a finite amount of time during the school day. Stop making this kid sit down for half an hour a day and try and write stuff out by hand and increase his penmanship. Not a good use of his time. I don't remember the last time in my my 14-year law career that I had to sit down and write out paragraphs by hand. We're all doing talk to text. We're all doing typing. We're all doing it using technology to write things out. So I think that was one really good result of that particular IEE. So in this case, the technology, I think, has been a real game changer for a lot of students and a lot of educators as well. Staffing support, this is always something that, I shouldn't say always, but this is very commonly something that comes up. A lot of parents are asking, because their student is not doing well, because they have concerns with bullying, because their student may not be progressing towards goals as quickly as we may want them to, ask for staff support. And whether or not to assign that paraprofessional, I think, is always going to be a balancing test. You obviously want students to have the human support, the staff support they need to do well in school, but then are being more restrictive than necessary. And that's going to be a case-by-case basis. You may need a para support for English, but you may not need one at lunch or at recess. So I think it's really fact and student specific. ESY services are intended to help students if they will regress, special ed students if they will regress over the summer months. If they will, then districts are obligated to provide ESY extended school year services. Question, ask yourself, which kid or which student, gen ed or special ed student doesn't regress over the summer? I think anyone who goes without, their formal education and training takes a 3-month, vacation from that or time off from that, they're almost always going to regress. That's always my argument. And we generally do get ESY services if we push hard enough. And I think that's something that's worth fighting for. Progress reporting. This is something that I read a lot of IEPs, both for special ed cases and guardianship cases that our firm does. And progress reporting that says 3 times a year, like twice during the year on report cards and once at the IEP meeting, so 3 times a year. I think that's never enough. If you only get to know essentially twice a year, other than the IEP meeting, whether your child is making progress on a document that's intended for them to make a year's worth of progress, I want to know at minimum every month how my student is doing. And gosh, wouldn't it be nice to know every week how my student is doing on their goals? So if I'm in the room and I'm working with parents, where we're asking for weekly, monthly progress reporting, daily sometimes, if we're going through a really tough period of having some behavioral issues, I want to know daily, what are the behaviors? What happened? What was the antecedent? What is going on that parents need to know, so that when kiddo comes home to the home setting, we can help process that and try and reduce some of those behaviors. As part of providing IEP services, districts also have to provide transition services, and those in Minnesota, make sure I'm right, must start in the 9th grade, and transition services are there to help kids transition out of public school setting and then into sort of the adult world of what are you going to do? Are you going to work? Are you going to go on to college, to tech school, to trade school, job training programs, whatever it is? Transition services are there to help students make that transition. Incidentally, I do see a lot of parents just decide not to pursue these. I think districts do a really bad job of advertising them because they're expensive and they don't meet the traditional model of, okay, you're going to go to your class, we're going to pull you out for 20 minutes and go back to class. A lot of times transition services just take place in a non-academic way. It's teaching kids how to, teaching job training skills, teaching kids how to live independently in an apartment, cooking, making change, creating a household budget. Those types of things oftentimes just don't fit really well within your traditional school day. And I find that a lot of kids who would otherwise qualify for transition services don't go, and sometimes parents are just like, what our district has offered us, this doesn't meet my kid's needs. A lot of districts have really good DD programs that are kind of a continuation of traditional special education programs. But for other kids who have different sets of special education needs, I've seen really a lack of transition programming offered. And so in Minnesota, those start in the 9th grade, and they have to go until age 22, which is a long time. Sometimes parents get so frustrated with their districts that they just like sort of at age 20 might be like, we're done. We've gotten enough services. We think that we've sort of extracted what we think we can get out of the district, and then we're moving on. That's a completely legitimate position to take, but just know legally, those would have to go into age 20. I'm right about 2 o'clock, Michelle. Do you want me to keep going? Oh, I mean, I can talk and take questions for a long time.
Go through the presentation. I've been emailing the one right after he was doing virtual.
Okay.
So I told him that we started too late.
Yeah.
So we can go from we'll take the questions after.
Okay.
and then we'll get him started.
Sure.
Does that sound?
Yeah, that's
It's
fine.
like 5.
Yep.
10.
Got it. So, this is a 2017 case. I don't want to get too much into case law other than, to let folks know that this is something that makes its way up to the US Supreme Court. The 2017 US Supreme Court is not the US Supreme Court that we have right now, although I will offer to you in a spirit of optimism that I think the special ed cases are fairly non-political. So we do hear a lot about the Supreme Court and the news media, and politics is going to be part of that. I think something that a lot of people may not know is a lot of cases the capital C court decides are usually decided by majority opinions, and a lot of them are just non-political. So it's questions of federal statutory interpretation, treaty rights, questions of federal law that are not necessarily interpreting the Constitution. And it's not people trying to litigate constitutional rights. It's and in this case, and so for in the sphere of special ed litigation, we're not asking the court to make any constitutional determinations. We're asking the court to interpret IDEA, the Individuals with Disabilities Education Act, or we're asking the court to apply prior case law to new facts, and case law that's based on IDEA, the Individuals with Disabilities Education Act. We had a really good decision in 2017 regarding Andrew F. when he was, I believe, and yeah, this was a Colorado case. And it was like, I'm getting back to my sort of previous remarks about how a lot of these cases are just really not political, and it's, you're asking the court to take up your issue and decide a federal legal question. So it was an 8-0. It was an 8-0 decision, meaning no dissenters. And it was really the first Supreme Court case to decide IEPs or decide an IEP issue since 1982, the year that I was born. So it had been a very long time since the court had looked at an IEP case. And the issue before the court was, what is the legal standard for looking at how sufficient an IEP is? And Andrew, poor kid, like he had been in and out of public school, private school. These parents were trying everything they could to try and get good education, good faith for Andrew. And what essentially happened is the district kept on, and a lot of parents have seen this, proposing the same goals and objectives year after year after year. The progress reports, students making minimal or some progress, and just were not really providing or promoting challenging goals for him. And eventually, but they kept on losing. So they lost at the administrative level. They lost at the federal district court. They lost at the Court of Appeals. So there were pretty high stakes going into the US Supreme Court because you're asking the Supreme Court to reverse course. And what they were asking the court to reverse course from was a prior case, the 1982 case that the court had decided, which I'll just call the Rowley case. And the Rowley case, the Amy Rowley decided in 1982, and it dealt with a completely different type of student. So Andrew has ASD, has behavioral needs, has very, very intense needs in the school setting. Amy Rowley in 1982, all she needed was a sign language. She didn't have an intellectual disability. She didn't have developmental disability. She's deaf. And the one thing the district was the one thing the parents were asking for, Amy was asking for, was a sign language interpreter, and the district said no. And the standard the court used essentially was, is the IEP allowing the child to achieve passing marks and advance from grade to grade? Back in 1982, they found that even though Amy Rowley didn't have a sign language interpreter, she was still doing good enough. She was getting passing marks and she was going from grade to grade. Well, that's not Andrew F. Andrew probably, because of his developmental and intellectual disability, is not going to be with his peers. So the court said, we need to look at a new standard. There are kids out there like Amy Rowley who need some minimal IEP services and some minimal supports. And there are kids like Andrew who might need a little lot of support within the public school setting to get paid. So the court essentially established a new standard for us. And this is at the bottom of the slide here. So now post 2017, rather than this prior standard of we don't need to provide a sign language interpreter because you're getting good grades, which is essentially what the court said in 82. In 2017, the court said the IEP has to be reasonably calculated to enable that child to make progress appropriate in light of that child's circumstances. So I like that as a litigator, because then I'm able to go into court and say, Your Honor, this particular student may not be meeting grade level expectations, but we're not asking for that. Here are the expectations that we're asking for. Here's the outside testing we've done with Mayo, with whoever, and we think that this IEP is effective because it's not robust enough, it's not challenging enough. And here's, by the way, my 3 outside expert witnesses who say, given the appropriate support, Johnny, who might be, in 8th grade, can go from a 2nd grade to a 3rd grade reading level within a year, given the right supports. And I would be allowed to make that argument in court. And if my witnesses testify the way I wanted them to, then I should be able to win under the new standard. So I'm going to end with that. Is the most recent case law that I have to present to you that touches on these issues. And I will take some brief questions if people have them. If anyone has any questions. Oh, sorry, I'm looking at the computer.
So just kind of like, in your experience and as an advocate for special education needs, just tying in with this last case law that you just presented to us for Andrew versus Douglas County School, what would you recommend as, like, are there any sort of areas we as maybe parents should kind of be looking for and looking at in coming up with like a comprehensive like IEP? Because we like until my son was diagnosed ASD, I was not familiar with IEPs. So it's been a learning process for me.
Sure.
So I've pretty much taken whatever has been recommended and suggested.
So take it from the district.
Exactly.
So like taking the district at their word. I mean,
Yeah.
I don't want to say that districts are always acting in bad faith.
Yeah.
I think we always need to challenge districts to provide. I want to be able to extract as much faith, so free and appropriate public education out of a district as I can. So I think parents are oftentimes their kid's own best expert. So I think parents oftentimes have the best sort of instinct as to, okay, in a year from now, what do I think my child can accomplish? If the district pushes back, I think that's a problem. So if it's, whether it be a behavioral issue or an academic issue, you are your kid's own best expert. So if they're saying that, he can go from 3 sight words to 5 sight words in a year, and you're like, no, you can go from 3 to 20 if he gets the right support. But I think that's what you need to advocate for. I will say, I think some of the most common mistakes that districts make, or things that I don't like about IEPs that I see, is that infrequent progress reporting. And when I ask the districts, show me your progress reporting data, those tracking sheets. It's like when you read your IEP and it says the goal, the objective, how will progress be tracked? It will be like, they'll say teacher notes, teacher observations, data tracking. 19 times out of 20, when I say to the district's attorney, can we just see your data sheets? They don't exist. So if I'm in your shoes, how old's your kid? 13. I mean, have you ever seen any progress reporting data? Like actual, they did this or didn't do this 3 out of 5 times on X date.
It's pretty much kind of like the, I guess, the report card where, or in the IEP where they might indicate, maybe of the goals we set at the beginning, like the academic year. And in my case, it's a little bit different because I just was from Canada. So I mean, there's similarities, but there are also like some differences. in how, things are done. But this is my first school year, like at least with my son who has autism.
Sure.
I've seen in the Rochester school, public school before, but it was my daughter.
Oh, okay.
Now it's coming back, and my son was diagnosed when I lived in Canada with autism.
Okay.
So now he's just started the register with school. So I guess my thing was kind of like I've pretty much kind of gone on what I knew from before,
Sure.
but I never thought of like, there ever being like the other than maybe US
Mhm.
or special ed. So I was kind of like, okay, so going forward, what kind of things maybe should I be looking out for? But like you mentioned, the whole asking for progress, like something a little bit more comprehensive in terms of, okay, we set these goals at the beginning of the year, at the beginning of the semester, like, what has he accomplished? And maybe if he hasn't accomplished any of those, it's maybe time to change course, or is it time to like leave that late?
Right. And that's why I think that progress, two of the most common things that I would say parents should do: demand more frequent progress reporting and actually see the progress reported data. So that they're trying to tell you that your student is doing something 3 out of 5 times with 80% accuracy. I want to know, show me that, who did that observation? Was it in the gen ed setting, in the special ed setting? Show me that data. We don't want to be in a situation where we draft an IEP, we agree to it September 5th of 2023, January 1st of 2024, they come and say, your student's making no progress. If they're making no progress, I want to know in October. I want to know now. I want to know after a month. What attempts have you made to work on this goal and objective? Are we making progress? If not, then we need to change something. So I think getting more frequent progress reports and then seeing the data that tracks progress reporting. If I had my way, districts would be automatically giving it more of that to my clients.
And so you request that through the district?
Yep.
Or through the school?
Through your IEP case manager, whoever your point person is, but oftentimes the case manager. Yeah. Anything else? You want me to wrap up, Michelle?
If you want to wrap up the phones and then other questions. You can take now by your booth,
Oh, sure.
and then I'll get Reminder started.
Great. Sounds good. Thanks, everyone. Have a good afternoon.
Thank you.